Picture this. It's a warm summer night, and you're parked at a scenic overlook in your RV. Kids are asleep in the back, stars are shining overhead, you're sipping a cold drink, unwinding from a long day on the road. When suddenly, bam, a sharp knock at your RV door. You open the door, and there stand two officers with flashlights blazing in your face, barking at you about a suspicious activity tip. They want to search everything. Your fridge stocked with groceries, your cabinets full of camping gear, even your kids' backpacks stuffed with snacks and toys. You're stunned. You've done nothing wrong, but the cops are acting like you're hiding a meth lab or stolen goods. Your heart is racing. Do you let the cops into your RV? Do you argue with them? Or do you know the magic words that will stop them dead in their tracks? I'm Jeff Hampton, the people's lawyer, and after handling thousands of cases and over 100 jury trials, I've seen lots of RV owners blindsided by the cops who don't know the rules or worse, bend the rules for their own agenda. In this video, I'm giving you the playbook for how to stop cops from searching your RV. We're going to dive into 3 exact scenarios where cops may try to search your RV or your campsite. And I'm going to give you the playbook step by step for how to shut them down. Situation number 1, the RV riddle. Is it your vehicle or your home? Here is the million-dollar question that trips up both cops and RV owners alike. Is your RV considered a vehicle that cops can toss like a beat-up sedan, or is it considered your home that cops can't get around or into without a search warrant? The answer is a game changer, and here's the wild part. Police often don't know the answer themselves. I've seen it in courtrooms from Texas to California. RV owners panicking, officers fumbling, and rights being trampled on. Under the 4th Amendment, your home has ironclad protection. Cops either must have a valid search warrant or they must have some type of exigent circumstance like an emergency situation or your consent to get inside. But a car? The Supreme Court's motor vehicle exception says that all cops need is probable cause to get into your car. This exception traces all the way back to Carroll versus United States, where Prohibition-era bootleggers got their car searched without a warrant. The court reasoned that a vehicle's mobility, its ability to move around, made it difficult for cops to pin them down, so they said that probable cause alone would be enough. That court ruling has held for almost a century, but it's not absolute in its application. So where exactly does your RV fall? The answer is not black and white, and it hinges specifically on the scenario, which is where most people, including cops, get lost. Take California versus Carney, the landmark Supreme Court case on RVs. Carney was living the dream. This guy was living in an RV in sunny San Diego, but he happened to be dealing a little pot on the side. DE agents tracked Carney, got him outside of his RV, and searched his rig, all without a warrant. Carney argued, hey, you can't search without a warrant. This is my home. But the court disagreed. They reasoned by saying, number 1, Carney was in a public lot at the time it was being searched. He had, quote, convenient access to the roadway, and his vehicle looked like it was ready to roll. The Supreme Court treated Carney's RV like a car, but they did leave the door open for other scenarios. An RV that's not mobile, let's say it's parked long-term, hooked up to utilities, clearly a long-term residence, may provide some 4th Amendment protection. Now, some state laws go further than this Supreme Court case. For example, in Oregon, in the case of State versus Kurokawa-Lasiak, the state Supreme Court ruled, and I quote, cops need a warrant to search any vehicle, RV or not, unless it's an immediate emergency. That's huge if you're an RV owner in Oregon. But not all state laws provide that extra protection. Now, what if instead of your RV sitting still, what if it's moving right on down the highway? Let's say you're cruising your RV down the highway, headed to Yellowstone, or maybe living the nomadic life. Cops then pull you over. Maybe it was a busted taillight. Maybe you failed to use your turn signal. Or maybe they're just fishing for a warrant check or looking to see if you have drugs. They stroll up to your window, knock on your window, want you to roll down the window, and now you can clearly tell they're looking to try to search inside your RV. Now, like we said earlier, when your RV is moving down the road, it's going to likely be treated as a car under the motor vehicle exception. Now, if cops have probable cause, let's say they see a baggie of weed sitting in on the dashboard. Maybe they look in and they see an open bottle of alcohol sitting there wide open. They're not going to need a warrant in order to get into your car because now they have probable cause. But it's certainly not a free-for-all. In order for the cops to get into your RV, whenever they pull you over under the motor vehicle exception, they're going to have to meet all 4 points of the motor vehicle exception. Number 1, the probable cause they're claiming must be specific, like I saw something illegal in the car in plain view. Number 2, your RV can't be in your curtilage. So if you have your RV parked within, like, let's say the detached or attached garage of your home, or maybe it's within the fenced off area within what is known as your home or your residence at the time. There, they can't search under that example because what are we talking about here? We're talking about that being as protected. Your curtilage is as protected as your home under the Fourth Amendment. In order for cops to do a search on curtilage, they're going to have a valid search warrant. Number 3, the search must match what they're actually claiming they have probable cause for. So if they're claiming they think you had a stolen TV in your RV, they can't go digging through your sock drawers of your RV. And number 4, the RV must be apparently mobile. Now what that essentially means is the RV has to be capable of being moved. But what if you're pulled over on the side of the road because you had a flat tire, or maybe you pulled over to take a nap? This brings us to the case of U.S. versus Howard. In Howard, the court allowed a stalled car on the side of the road to be searched by the cops, and it met the apparently mobile test here because it was only temporarily disabled because it only needed to be towed where it could then be fixed to allow to be driven. But what if your RV's broken down completely? Maybe you're stranded on I-40 with a blown engine. Legally, it's still mobile. In fact, U.S. versus Steger ruled that a truck with a dead battery on the side of the road was still seen as apparently mobile because it could be moved after a charge. In Steger, the court very heavily emphasized that even a car that needs heavy repairs, extensive repairs, can still be seen as apparently mobile. But here's your edge. If the cops' claim of probable cause to search your RV is pretty shaky, maybe they're just trying to dig in there and see whatever they can find, you can try to stop them both potentially there on the side of the road and certainly in a courtroom by refusing consent. So let's try something different. Let's say you're at a festival. Maybe you're at Coachella or Burning Man. Your RV is parked in the lot, but you've been driving it around the grounds. Cops roll up with a drug tip and they want inside. Let's apply the Carney test. Is your RV apparently mobile? Yes, it is. You've been driving it around the lot. Does your RV have convenient access to the roadway? Sure, particularly if you're near the exit. Now, if cops now have probable cause, like a pipe in plain view, they're going to get inside your RV. But if it's hooked up to a generator, slides out, and a home sweet home sign sitting out, you might have the law on your side. That brings us to our next scenario. What if your RV is parked and now unmovable? So now let's say your RV is parked on a concrete slab at a friend's farm in Tennessee, hooked up to water and power, propane grill out front, and a welcome mat by the door. You're living there, maybe for weeks. Can cops treat this RV like a car? Not so fast. If it has no convenient access to the roadway, permanent hookups, no valid registration, and you've got a pickup for driving, it's not a vehicle. It's going to be considered your home. Now that's full Fourth Amendment protection. Cops either now need a warrant or they need an emergency situation. In U.S. versus Adams, cops searched an RV in a rural area that was attached to a generator, and they had another car that you could clearly tell they were using for transportation, and there were no immediate roads that were nearby. The court ruled that the RV was now a home, a residence that had Fourth Amendment protection, and they tossed the cops' search as being illegal because they tried to treat it as a car when they should have given it the Fourth Amendment protection of a home. In People versus Schaefer in California, the court ruled there that an RV in a driveway fixed with utilities with those permanent hookups was also considered a home. The key in Schaefer is that the RV had been parked for months, and it was clear that it had been sitting there for months, and it was permanently hooked up to the utilities, clearly showing it wasn't planning on going anywhere. So what if you're at a long-term campsite with blocks under the wheels, slides out, and a patio with string lights. Here, we're still talking about it being your home. But what if it's on a friend's land or maybe a leased plot? It doesn't matter because courts are focusing on the setup, not on the ownership. Okay, so if your RV can now be considered your home, what about your truck that's parked nearby? In the Supreme Court case of Collins versus Virginia, the court said that the area immediately surrounding your home is known as curtilage. And anything that's parked in that curtilage area of your home is also protected under the Fourth Amendment, and the cops must have a search warrant. So, if your RV is considered your home now, then your truck that's parked right next to it, or maybe under the carport that's attached right there near it, is going to also be considered curtilage with Fourth Amendment protection. In Collins, cops searched a motorcycle that was under a tarp that was right in the attached area near the home nearby, and the court said that it was an illegal search because the motorcycle was parked within the curtilage of the home. When you set it up the right way, your RV is now your castle. Lock the door, post a no trespassing sign, and tell them to get lost legally. Okay, our next scenario. You're at your RV. It's parked at a state park. Maybe you have it all hooked up with utilities and water, electricity. And instead of staying inside the RV, you are now staying in a tent nearby, near the RV. Your gear is all spread out all over the place. You have a nice little campfire sitting there in your tent. All of a sudden, the cops roll up. Maybe a ranger claims they heard some noise going on, or maybe the cops are just out snooping. Can the cops now search your tent or your RV? For the RV, we have to ask the quick questions. Number one, is my RV hooked up to the utilities? Check. Number two, do I have blocks under the wheels, and am I in a place where this moment where I don't have immediate access to a roadway? So if I'm pretty secluded back into the state park and I'm not near an immediate roadway, check. Finally, do I have a separate vehicle for transportation? Did I bring my truck? Maybe it's a pull along, right? In that situation, check. That being the case, there's a better chance your RV is going to be treated as your residence, and they're not going to be able to try to treat it as a car under the motor vehicle exception. But what about your tent? That brings us to U.S. versus Gooch. In this Supreme Court case, the court ruled that a tent at a legal campsite has full privacy rights. In Gooch, cops searched a guy's tent after days of camping in Washington, and they didn't have a warrant, and the court threw it out. The court said, and I quote, "One should be free to depart the campsite for the day's adventure without fear of this expectation of privacy being violated." In Gooch, the defendant was legally camping in a national forest, and the court saw his tent as his home while he was there. But watch out if you're camping illegally or you're squatting on private land. In Rockus versus Illinois, the Supreme Court ruled that trespassers have no legal privacy rights in places they don't have a legal right to occupy. Now here's another one many people have asked me. What about a pull trailer? In U.S. versus Irvin, the Supreme Court ruled that a search of a pull trailer was legal under the motor vehicle exception. In other words, you get no Fourth Amendment home type protection. Why? Because it was hooked up and ready to go. In Irvin, even though the pull trailer was parked, it wasn't going anywhere, the court said that because it was hooked up to a truck, that made it apparently mobile and ready to go. Pull trailers will be seen more like a vehicle, but your tent, you should zip it up, keep it private, and if you're camping legally, it is your fortress and you have Fourth Amendment protection. The court reiterated this rule for your tent in U.S. versus Basher. In fact, in that case, the court said that if you are camping legally, and in that case it was on an actual federal land at a park, that you are now known to have an expectation of privacy, that the police can't just come roaming around or digging into your tent any more than they can come digging into your home. Think about this next time you're out camping. You're at a national forest campsite, RV hooked up, tent is pitched. Cops show up at 2 a.m. claiming something suspicious. You step out, you zip the tent, and you say no consent to search. The RV is considered your home. It's hooked up, the slides are out, and the tent's your bubble. No warrant, no entry, unless they see a crime in plain view. Finally, here's the payoff. Here are the battle-tested 7 tips to stop cops from searching your RV or your tent anywhere and anytime. Number 1, if cops pull over your RV while you're driving down the road, remember to stay calm and in control. You know you have to give the cop your license and your registration because it's required by law. But anything else other than that, it's time to shut it down. Officer, I exercise my right to remain silent, and I will not answer any further questions without my attorney present. This simple phrase puts you in the driver's seat, and here's why it works. When cops pull you over and they walk up to your front window and they start talking to you, your demeanor and how you respond makes an enormous difference in how this is going to turn out. Stay calm, keep your hands on the wheel, and avoid any sudden movements where cops can now claim their officer's safety is at risk and get you out of the RV. You always have a right to remain silent, and if the cop starts asking you questions like, "Where'd you come from?" or "Where are you headed?" you can be polite, but you can tell the officer, "Officer, I exercise my right to remain silent." At this point, you can turn around to the officer and ask, "Officer, am I free to go?" You place the officer in a position that if he's going to write you a ticket for what he pulled you over for, now's the time he has to do it. Or if he doesn't have anything to hold you for, he has to let you go. Number 2, always refuse consent. If the officer asks to look inside, it's very simple. You say, "Officer, I do not consent to any search." You can be clear, you can be firm, and you can be polite. But you have to understand that consent waives everything, so you must not budge. You have to understand that you providing consent hands over your Fourth Amendment rights on a silver platter to the police. And to further emphasize this, in Schneckloth versus Bustamante, you have to understand that we learn here cops can be tricky. They can lie to you. Yes, you have a right to refuse consent, but cops don't have to tell you it's optional. So if they start shaking you down, trying to make you feel like, "Hey, if you got nothing to hide, why wouldn't you let me search your car real quick?" Or, "Hey, this is only going to take a few minutes. I don't want this to get worse for you. It's going to go easier if you let me search your car." You have to understand cops can lie to you in this situation. They're allowed to trick you in this situation. So regardless of what the officer says, always refuse consent to a search. Refusing consent doesn't stop a search if police have probable cause already, but refusing consent gives you the opportunity to challenge the search later in court if the cops did something wrong. Literally practice this out loud. I tell my clients this. To practice, I do not consent. I even thought about getting t-shirts that say, "I do not consent." Number 3, make your RV a home. If you have your RV parked, set up utilities. Put wheel blocks underneath it. Set up camp. Put awnings over it. Put a welcome mat down on the entry door. Even put out a mailbox. When you take these actions, courts will see a home, not a car. When you take these actions, you're not just camping, you're fortifying your fortress. And if you don't want cops looking through the windows of your RV, lock your doors, close your blinds. No plain view freebies. And here's the strategy. Courts decide on whether your RV is a home based on its setup, not who actually owns it. In U.S. versus Ludwig, an RV that was parked with its steps down and plugged into power was considered to be more of a home than a car, and in fact, the court said that there was an indicia of habitation. So always connect to electricity, water, and sewage if you can. Drop the jacks, extend the slides, and roll out the awning. Put out a grill and put out some chairs out front. Anything that screams, "I live here." When you have your RV set up like a home, when a cop comes to your RV door and he knocks, that's no longer him trying to get into your RV. This is nothing more than a knock and talk. And remember, we've talked about this on previous videos. If a cop comes to your door during a knock and talk, you can completely ignore them and not even answer the door. Number 4, leverage the concept of curtilage. On private land or a campsite, keep your RV and your truck within a fenced area or privately marked off area so that it could be more likely to be considered curtilage. Remember, if your RV is considered your home, if your vehicle is parked nearby, that is going to be considered on the curtilage of your home, so the cops can't come up and start snooping around and looking in your truck or your car either. For RVs, even if it's not your RV, maybe you're there visiting a friend of yours that has an RV, park within the fenced lot near their RV so that it's going to be considered curtilage. Or maybe it's a private lot. Park at or near the area that would be considered the home or the residence, or maybe even the tent. If you're near the tent, park your vehicle right near the tent because it has the same protections and Fourth Amendment privacy rights as your home. In Florida versus Jardines, the court ruled that your curtilage is sacred. They wouldn't even allow a drug dog to walk around on the front porch of a home without a valid search warrant because that was a violation of the homeowner's privacy rights. If cops are at your campsite and they start coming up trying to talk to you, point out the boundaries of your assigned spot in the campsite and let the officers know, I do not consent to you coming within this area of my campsite that is now considered my residence. I do not consent to a search or to you entering this area. Now, in Hester versus United States, the courts did say that curtilage does not work in public lots or open fields, but on private ground or a defined site, it is your turf and you can assert your constitutional rights, your Fourth Amendment rights in that situation. Number 5, always use campsite power for your RV. If you're hooked up to utilities at a park and cops come up to your RV door, don't open the door. Just talk through the door and ask the officer if he has a warrant. If he doesn't, say, Officer, I do not consent to you entering and I will not open the door without a valid warrant. I mentioned U.S. versus Gooch earlier because in that case, the court really saw the actual hookup of the power to your RV as a bit of a game changer and to help establish that it was more of a residence and a home than a car. Number 6, if you're camping, turn your tent into a fortress. At a legal campsite, if a cop show up, you can step out of your tent, zip it up, and say, Officer, I do not consent to a search. Your tent at a legal campsite is your home away from home, and the Supreme Court says you can own it. In fact, to expound on this, in the court case of Stoner versus California, the court said that your privacy interest in a tent is very similar to the same privacy interest you would have in a hotel room. Where most people go wrong is they don't zip up their tent. Maybe the tent is there and the flaps are open. What do you think the cops are going to do? They're going to walk in and they're just going to look inside, and anything they see in plain view, they can now claim they have a right to enter into the tent, potentially based upon that probable cause, and now they're able to search your tent. So remember, always camp legally. Zip up your tent, lock it down, and you will have Fourth Amendment privacy protection. Finally, number 7, always know your specific state laws. States like New Mexico and Oregon require cops to actually have a search warrant to do any of this stuff. They can't just rely on the old federal rules. Always remember, federal rules, federal laws are the floor. They're the most basic rights that you have. But different states actually add to it and create a higher ceiling of additional privacy rights you can receive, which is why you should know your state laws, your state constitutional rights, and don't ever assume that your cops that you're dealing with in that situation know what they are. If you arm yourself with your laws and your rights, you'll know how to stand up for those rights and make sure you never consent and make sure that you protect yourself if cops overstep their boundaries. And finally, bonus tip, if cops ignore your rights and they try to search you anyway, do not physically resist. Instead, just repeat over and over again and record the entire interaction. Repeat, I do not consent. Make it very clear so that you're protecting yourself if the cops are overstepping your boundaries. And remember, when you have your RV or your tent is treated as your home with those same Fourth Amendment protections, under the case of French versus Merrill, if cops ignore your rights, they may lose their qualified immunity and you may have a Section 1983 federal lawsuit, civil rights lawsuit, you may be able to bring to hold the police accountable if they violate your constitutional rights. So there you have it, your guide to stop cops from searching your RV or your tent, forged from real state and Supreme Court case law. But what if cops pull you over and they start using those tricks we talked about earlier, legal tricks on you during your traffic stop? Check out this next video where I break down how to stop cops from tricking you during a traffic stop. I'll break it all down. See you over there.